Warm greetings everyone. I am Dr. Purnima Khanna from Khalsa College of Law, Amritsar. Our topic of discussion is the dissolution of marriage under Christian law. The learning outcomes from the present module will be introduction about the topic, various theories of divorce, then the divorce under Christian law, including the fault grounds of divorce as well as the divorce by mutual consent. We will also discuss about the recommendations of the Law Commission of India on the subject matter. Finally, the conclusion of the topic will be discussed. First of all, let's begin with the introduction of the topic. What God has joined together, let no one separate, is the sublime ideal read in the Bible. In the light of this statement, let's discuss the law relating to dissolution of marriage under Christian law. All the citizens of India professing and residing in India are governed by the Indian Christian Marriage Act 1872 in the matters of conditions relating to solemnization of a Christian marriage. While in the matters of dissolution of a Christian marriage, they are governed by the Indian Divorce Act 1869. Both these legislations are based upon the law prevalent in England. Furthermore, it is worthwhile to note that the nature of a Christian marriage is both sacramental as well as contractual. According to Roman Catholics, marriage is an indissoluble union and they do not recognize the concept of divorce. However, it is important to note that a Christian marriage can be dissolved by the Divorce Act 1869 and it is applicable to both Roman Catholics as well as the Protestants. Now let's discuss various theories of divorce. Divorce is considered to be a harsh matrimonial remedy as it puts end to a marital relationship between the parties. However, in certain cases, it becomes unavoidable as it may end the sufferings of the party unable to live together due to various reasons. This remedy is available under the personal laws of all the citizens of India. Before discussing the concept of dissolution of marriage under Christian law in detail, it is important to get an insight into the three theories of divorce. The first theory is the fault theory. The fault theory of divorce is also known as the offense theory or the guilt theory. Therefore, it highlights the point that a marriage can be dissolved when any of the parties within the bond of matrimonial ties commits an offense against the innocent party of the marriage. Thus, it is necessary to have a guilty partner as well as an innocent partner within the bond of matrimonial ties. The innocent party only holds the right to seek the remedy of the divorce. It is necessary to have a guilty as well as the innocent party, and only then the innocent party can seek the remedy of divorce. However, the most striking feature as well as the drawback of this theory is that if both the parties have been at fault, then there is no remedy available for them. Second theory is mutual consent theory. The underlying rationale behind this theory is that since two persons can marry by their free will, they should also be allowed to move out of the relationship out of their own free will. In any case, it is highly criticized that this methodology will advance immorality as it will prompt rushed separations and the parties would break down their marriage regardless of whether there was a slight contradiction of personality. The third one is irretrievable breakdown of marriage theory. This theory is defined as failure in the matrimonial relationship owing to such adverse circumstances that no reasonable probability remains for the spouses to stay together. As a result of such adverse, impossible conditions and situations, the husband and wife cannot ever stay together. Such marriage should be dissolved with maximum fairness and minimum bitterness, distress and humiliation. Thus, we can say that in such cases, there is a stronger reason to live apart compared to the emotions of love, affection, and loyalty that should commonly prevail between the husband and the wife. Therefore, the basic rationale behind this theory is that if a marriage is beyond all the possibilities of a repair, then it should be brought to an end. When a marriage is not able to last, then there is no point in sharing rights and obligation between the two parties. The Indian Divorce Act 1869, it is a pre-independence act enacted by the Britishers during their rule in India, as it is still applicable to the whole of the India. This act was recently amended in 2001, where a number of important changes were made to the act. Let's discuss the basic changes introduced by the Indian Divorce Amendment Act 2001. In 2001, reformation of the Divorce Act 1869 took place. This debate was focused on the reform of Christian personal law and attempted to do away with a number of discriminatory provisions such as compensation for adultery and the fact that women needed to supplement adultery with cruelty or any other ground while pleading a ground for divorce. But at the same time, this was not the case for the husband. While the amendments addressed a number of discrepancies, the government also conceded to the recognition of certain exceptions. For instance, despite the majority of the population of Nagaland being Christian, the state was granted an exception, and the amendments to the Act of 1869 are not applicable in Nagaland. This was owing to the Naga Accord signed in the year of 1961 to ensure the territorial integrity of India in exchange for granting exceptional status to Nagaland with respect to domestic or personal laws that applied in the state. The major changes introduced by the amendment of 2001 are: number one, the requirement that a woman must prove cruelty or desertion on part of her spouse in addition to the adultery to obtain divorce has been removed. Now, divorce is available to the women on the ground of adultery, cruelty, or desertion. Earlier, there was no provision for the divorce by mutual consent. However, the present Act after the amendment of 2001 allows divorce by mutual consent to Christian couples who feel that their marriage had failed due to incompatibility and cannot be revived. This was the most important and welcomed change as far as the Christian community is concerned. Further, under the Indian Divorce Act 1869, as amended in 2005, a wife may, apart from the grounds available to both the spouses, also present a petition for dissolution of her marriage on the ground that the husband has, since the solemnization of marriage, been guilty of rape, sodomy, or bestiality. In the 2001 amendment, the clause of 2-year separation had been preserved by the Parliament, keeping in mind that the Christian community and in particular the Catholic community had not been historically in favor of divorce. Showing consideration to such religious sentiments, the government had in fact hesitated even from the use of term divorce altogether, referring to it instead as dissolution of marriage. However, many Christian women's organizations have argued that the period for confirmation of a decree of divorce is significantly longer than for the couples of other religions. Now, let's discuss the fault grounds available under the Indian Divorce Act 1869. As per the bare provisions laid down by Section 10 of the Divorce Act, it is provided that on a petition presented to the district court, either by the husband or by the wife, any marriage solemnized whether before or after the commencement of the Indian Divorce Amendment Act 2001, the marriage may be dissolved on the basis of following fault grounds. The first one is adultery. If one of the spouses commits adultery, the aggrieved spouse may file for divorce. Under Christian law, before the 2001 amendment in the Indian Divorce Act 1869, for a woman to seek a decree of divorce on grounds of adultery, it was insufficient until she also included cruelty as a ground for divorce. However, in 2001, this was amended and both men and women were given the right to seek divorce on the grounds of adultery alone. Further, it also did away with the provision of compensation for adultery, finally acting on the recommendations of Law Commission of India in its 15th report, which was titled as Law Relating to Marriage and Divorce Amongst Christians in India in the year of 1960. Adulterer or adulteress to be a co-respondent in the proceedings of divorce. The Indian Divorce Amendment Act 2001 has substituted the Section 11, and it is provided that in case of a petition for dissolution of marriage has been filed on the ground of adultery, then the adulterer or the adulteress shall be made co-respondent in the petition. It is further provided that the petitioner may not make the adulterer or the adulteress a co-respondent in the petition in the following circumstances. Number one, if the adulteress wife is leading the life of a prostitute, or the adulterer husband is leading an immoral life and the petitioner is unable to know the person with whom the adultery has been committed. In spite of the full efforts, the petitioner is not able to know the name of the alleged adulterer or the adulteress, or in case the alleged adulterer or adulteress is dead. Now, the second fault ground of divorce is conversion. If one of the spouses has ceased to be a Christian by conversion to another religion, the aggrieved spouse is entitled to file for divorce. Thirdly, the ground is unsoundness of mind, where one of the spouses has been incurably of unsound mind for a continuous period of not less than 2 years. Immediately preceding the presentation of the petition, the other spouse may file for divorce. Then the next ground is venereal diseases. If a party to marriage has been suffering from a venereal disease, that is in a communicable form, for a period of not less than 2 years, immediately preceding the presentation of the petition, the aggrieved spouse can file for divorce. Next, whereabouts of the spouse are unknown for total 7 years. If the respondent spouse has not been heard of as being alive for a period of 7 years or more by those persons who would naturally have heard of the respondent, if the respondent had been alive, a ground for divorce is raised in favor of the aggrieved spouse. Coming to the next ground, it is willful refusal to consummate. If the marriage has not been consummated due to willful refusal by a spouse to consummate, the aggrieved spouse may file a petition for divorce on this ground. Next ground is non-compliance of a decree for restitution of conjugal rights. The plaintiff spouse can file a petition for divorce on the ground that respondent spouse has failed to comply with the decree for restitution of conjugal rights for a period of 2 years or more after the passing of the decree against the respondent. Next ground is desertion. Desertion of one spouse for at least 2 years immediately preceding the presentation of the petition is also a ground for divorce under the Christian law. Section 3, Clause 8 defines desertion as an abandonment against the wish of the person charging it. Next important ground is cruelty. where the respondent has treated the petitioner with such cruelty as to cause a reasonable apprehension in the mind of the petitioner that it would be harmful or injurious for the petitioner to live with the respondent. The petition for divorce may be filed. My dear learners, here we must also discuss the recommendations of 15th report of the Law Commission of India. The 15th Law Commission report on law relating to marriage and divorce amongst Christians in India in the year 1960 did not culminate in successful legislation, and it faced opposition from the Catholic Church. In early 1960s, the amendments to Indian Christian Marriage Act 1892 were introduced in the Parliament, but the bill lapsed. In 1969, the Indian Divorce Act 1869 was amended, but this did not accommodate most of the concerns raised by the Law Commission. It is owing to the failure of the legislative intervention that family law has largely been interpreted by the courts in our country. The courts in many ways have had to lead the way to reform the personal laws of various communities. The Law Commission of India observed that Indian Christian law on marriage has remained the same since its inception, and the criticism that it has become antiquated and to some extent obsolete is well-founded. The Commission recommended that it shall be amended to suit the present conditions. Further, it was recommended that the two statutes, that is, the Christian Marriage Act 1872 and the Indian Divorce Act 1869, shall be consolidated into one comprehensive law, dealing with both the law relating to marriage as well as the matrimonial remedies. The Commission also suggested that the title of such consolidated law might be the Christian Marriage and Matrimonial Causes Act. Another important provision is divorce by mutual consent under the Christian law. Section 10A, which was inserted in the Divorce Act 1869 by the Indian Divorce Amendment Act of 2001. It lays down that a petition for dissolution of marriage may be presented to the district court by both the parties to a marriage together, on the ground that they have been living separately for a period of 2 years or more, that they have not been able to live together, and they have mutually agreed that the marriage should be dissolved, on the motion of both the parties, made not earlier than 6 months after the date of the presentation of the petition and not later than 18 months after the said date, if the petition is not withdrawn by the parties concerned. The court shall, on being satisfied after hearing both the parties and making all the inquiries that a marriage has been solemnized and that the averments made in the petition are true, it shall pass a decree declaring the marriage to be dissolved, and from the date of such decree. However, the court shall be satisfied of absence of any collusion. Section 12 of the Act lays down that upon such petition for the dissolution of a marriage, the court shall satisfy itself in the absence of any collusion between the parties regarding the facts alleged. The court should also ensure that the petitioner has not been in any manner accessory or conniving at the going through of the said form of marriage or the adultery, or has condoned the same, and shall also inquire into any counter charge which may be made against the petitioner. How such petitions can be dismissed? Section 13 of the Act provides for the provision regarding the same. It provides that for the purpose of dismissal of petition for dissolution of marriage by the court shall be satisfied on the evidence in relation to such petition that number 1, the petitioner's case has not been proved, or secondly, the court is not satisfied that the alleged adultery has been committed, or the court finds out that the petitioner has during the marriage been accessory to or conniving at the going through of the said form of marriage, or in case the adultery of the other party to the marriage or has condoned the adultery complained of. Also, if the court finds that the petition is presented or prosecuted in collusion with either of the respondents. Now let's discuss about the power of the court to pronounce decree for dissolving marriage. Section 14 of the Act provides that in case the court is satisfied on the evidence that the case of the petitioner has been proved and doesn't find that the petitioner has been in any manner accessory to or conniving at the going through of the said form of marriage, or the petitioner has not condoned the adultery of the other party, or that the petition is presented or prosecuted in collusion with the respondents, it shall pronounce a decree declaring such marriage to be dissolved. However, it is also provided that the court is not bound to pronounce such a decree if it is found that the petitioner has during the marriage been guilty of the adultery, or in case the petitioner has, in opinion of the court, been guilty of unreasonable delay in presenting or prosecuting such petition, or the petitioner has been guilty of cruelty towards the other party to the marriage. Also, if the petitioner has been guilty of having deserted or willfully separated himself or herself from the other party before the adultery complained of and without reasonable excuse, or if the petitioner has been guilty of such willful neglect or misconduct towards the other party, or himself or herself has encouraged the adultery. It is noteworthy that no adultery shall be deemed to have been condoned within the meaning of this Act unless where conjugal cohabitation has been resumed or continued. What is the relief in case of opposition on certain grounds? Section 15 of the Act lays down that in any suit instituted for dissolution of marriage, if the respondent opposes the relief sought on the ground that petitioner has also committed adultery or cruelty or desertion, the court may in such suit give to the respondent on his or her application the same relief to which he or she would be entitled in case he or she had presented a petition seeking such relief. However, the respondent shall be competent to give evidence relating to such adultery, cruelty or desertion committed by the petitioner. It is to be noted that all the decrees for dissolution are to be considered decree nisi. Section 16 mandates that every decree for dissolution of marriage made by a high court shall in the first instance be a decree nisi, that is, not to be made absolute till after the expiration of such time, which shall not be less than 6 months from the pronouncing of the decree, as the High Court directs. During that period, any person shall be at liberty to show cause why the decree should not be made absolute by reason of the same having been obtained by collusion or by reason of material facts not being brought before the court. On cause being so shown, the court shall deal with the case by making the decree absolute or by reversing the decree nisi or by requiring further inquiry or otherwise as the justice may demand. Whenever a decree nisi has been made, the petitioner fails within a reasonable time to move to have such decree made absolute, the High Court may dismiss the suit. My dear learners, the foregoing discussion highlights that Christian law on the dissolution of a marriage has undergone numerous changes since the 2001 amendment. The Christian wife's right to divorce has become on par with that of a Christian husband. However, unlike Hindu laws, there are no special grounds for divorce available to a Christian wife if the husband is guilty of rape. Further, the divorce by mutual consent was inserted in 2001. However, the divorce on the ground of irretrievable breakdown of marriage is yet not being provided under the Christian law. With this, we come to an end of today's lecture. Thank you very much.